Thank you, Mr. Chairman. I'm so glad that we're having this much needed debate in our country, and especially in this committee on the dire need for reform in our criminal justice system. I really want to go back to the discussion on drug offenses and mandatory minimum sentencings. Mr. Chairman, I have in front of me a statement offered to this committee, to this hearing from Human Rights Watch that echoes many of these concerns. I'd like to have this statement entered into the record.
Without objection, so ordered.
Thank you. Regarding prosecution and mandatory minimums, Human Rights Watch explains that, and I quote, "Mandatory drug sentencing laws have given prosecutors too much power. They are able to strong-arm drug defendants by offering them a choice, significantly shorter prison terms if they plead guilty and excessively severe sentences if they go to trial. Coerced pleas and disproportionately harsh sentences should not be part of the federal criminal justice system." And my colleague from Oklahoma began this discussion on that already, and I'd like to further this sort of power relationship. Mr. Ring, you said that prosecutors in your case initially asked for a 20 to 27-year sentence. That seems incredibly excessive for a nonviolence offense. You know, I have to wonder, you came into the system as someone you know, fairly highly educated, a lot of experience, not easily intimidated, I would think. And I just wonder, you know, what your experience was in terms of facing that potential mandatory minimum, and then thinking about the folks that you saw when you were in prison. And if you think about someone whose entire life experience begins with stop and frisk and unnecessary police stops and a law enforcement system, while we have great law enforcement officers, but a system that is skewed, especially towards minorities, what that does to that power relationship between the prosecutor and the defendant.
Thank you. Let me just say, I try to always make clear that my case is definitely unique. I mean, I'm a congressional staffer, I'm a lawyer, I worked for sentencing reform, I knew a lot of these issues, and so it was certainly a different situation. The reason I usually raise it is just because I want to show how much power the prosecutors have without mandatory minimums, because they were able to threaten that sentence because the guidelines are still so high too, and the guidelines are usually driven by the mandatories. So when you lifted the drug mandatory minimums, the white-collar folks on the commission said, we got to lift these up too to make them to have parity. So the guidelines are very high too. The people I saw in prison looked nothing like me. I mean, I hope it's clear, and I don't think everyone knows, that there's no club fed. I mean, I was definitely a minority in the prison. Most people are brown and black, and that's another problem in terms of getting programming to such a disparate group of people. But these folks faced mandatory minimums. They didn't know anything. They know nothing about sentencing law. It's such the divorce between what members or politicians think that is going to deter a criminal, as if they are listening to, you know, that if you pass a 5-year mandatory minimum, the next year they're going to, oh, I'm not going to do that anymore because they just stiffen these penalties. There's no idea. Most of these guys made stupid mistakes without any idea of what the punishment was. They just didn't think they were going to get caught. So you can make the severity off the charts. You can do life sentence for jaywalking. It's not going to stop it. So it is a problem. These people don't know. There's a lot of bad lawyering, and some of these people had really terrible representation. And so the people who can't afford it, and I don't know anybody who can't afford to go to trial today, it's a huge problem. And so I think that's why you see so many lower-level people who have no resources just cave to the system.
All right. Thank you. Mr. Tolman, as a defense, with your experience as a defense attorney, have you seen defendants discouraged from exercising their right to trial? And I want you to speak to this power relationship, because it seems like the way this is set up, it just gives excessive power to prosecutors, and that you have a defendant, you know, who's from a community where they see all their buddies or their friends who get stop and frisk and minor drug offenses end up in jail for these long periods of time. I would think that that power relationship is just excessive.
It is extreme power. We could, as a federal prosecutor, I could control what the sentence would ultimately be because of our ability to wield the particular statutes we wanted, because of the guideline ranges, because of enhancements we could apply, and we controlled the ability to also go down from those guideline ranges. It influenced me as a defense attorney so that my practice currently, I tell many of my clients, we need to be successful prior to you being charged, or we need to be cooperating in a way, or we need to show the government that we are going to be very different than just an individual that they prosecute and goes to trial. I cannot in good conscience advise any of my clients at this point to go to trial, because the resources and the evidence and the penalties present incredible obstacles to exercising your constitutional rights.
Thank you. I'm out of time, Mr. Chairman.